In this video, I just want to talk a little bit about why certain people should not remove their case from the court. I know this might sound controversial because I always, almost all the time, advise people to remove themselves from immigration court if they can, because they can adjust status if they are prima facie eligible to adjust status. But sometimes you have to stay in court because you are not prima facie eligible to adjust status, even though you have I-130 approved. In this video, I am going to talk about those type of scenarios. My name is Bijoux, Ngwanda, I'm an immigration lawyer. As you know, it's here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Let's get right into it. Well, we had a client where her case was in removal. She found herself in removal because the husband asylum was terminated, okay? But because the client had has a daughter, okay, and the daughter petitioned for her, I-130 was approved. Of course, if you can establish relationship, well, of course, the I-130 is going to get approved. So now the question became, should I try to adjust in court or should I try to adjust with USCIS? Well, the previous lawyer advised that you should adjust with USCIS. We should dismiss this case. But what they failed to mention to the person that because you have a case of misrepresentation before, adjusting with USCIS is not going to work. Why? Because you don't have a qualifying relative for the purpose of waiving fraud, willful misrepresentation. In order to waive fraud or willful misrepresentation, you have to have a qualifying relative. It has to be a parent or a spouse, lawful permanent resident, or U.S. citizen. The client did not have either. So, but unfortunately, they removed her, like dismissed the case because I-130 was approved. They failed to actually realize that the client was not prima facie eligible to adjust status, okay? And if the client had stayed in court, she could have applied for asylum because that was one of her defense, asylum. And given that the asylum of her husband was terminated, she could have applied for asylum on her own at that point. And change of circumstances really was actually a good and valid reason back then, because that's when the husband asylum was terminated, okay? And at that point, there's a change of circumstances in her situation that will warrant her own asylum claim even late. And in court, you can really argue that really well because that's where you are. But unfortunately, they failed to really realize that she was not prima facie eligible to adjust status based on fraud, willful misrepresentation, no waiver because she doesn't have a qualifying relative. Well, now green card was denied because waiver was not granted, lack of qualifying relative. Now what's going to happen? You're going to go back to your old asylum with USCIS. But the thing is, now how are you going to claim change of circumstances, even if you can claim change of circumstances or extraordinary circumstances? But the thing is, it has to be filed within reasonable time, right? You claim change of circumstances or extraordinary circumstances that are pretty much giving you the eligibility to apply late for asylum, but it has to be done within reasonable time when you notice that change of circumstance. Now the argument becomes difficult. You see, that was one of the reasons from the get-go. If If she had done proper consultation with other lawyers, they could have told her, yeah, because you have willful misrepresentation, you don't have qualifying relative, adjusting status with USCIS, it's just not going to work out. To stay in court, defend your asylum. And this is the best place to defend it. And the judge has a lot of discretionary power. And, you know, now you're starting over. After being in this country for almost 40 years, this is a really difficult situation to be in, okay? Yeah, another time you don't want to leave the court, it's because if you dismiss your asylum claim, what are you going to do? Because the moment you go back to USCIS with the same asylum, it's going to be dismissed again, because they will say that we already adjudicated this asylum. Those are for people who were referred to court, right? And then in court, they took a dismissal. But the thing is, if you don't have, unless the claim of asylum was weak, but if you don't have any other solution and the claim is strong, just stay there and defend it all the way to the end. Otherwise, once you dismiss it, you don't have qualifying relative to file for I-130, you stay like that, right? But if you have a qualifying relative to file for I-130 and you are prima facie eligible to adjust status, then you can go ahead and adjust status, right? But if not, then you're stuck. Those are those two situations where I advise people to stay in court and defend their case in court and take the risk, because sometimes in life you take the risk, right? Under other circumstances or under other set of facts, I will strongly advise for you to remove yourself from court, because you don't want to stay there, right? So this is it for today, my friend. If you need a consultation with me, again, you should schedule it by using the consultation link in the description box below. Until next time, bye-bye.